Monsieur will pardon me, but he is connected, is he not, with the affair at the Villa Genevieve? Yes, I said eagerly. Why? Monsieur has not heard the news, though. What news? That there has been another murder there last night. What? Those words were from Agatha Christie's 1923 novel, The Murder on the Links, one in the Poirot series. There was a double murder. Here, on this week's show, we also have a double murder, one case from the Sixth Circuit and one from the Fifth Circuit, both involving a murder. They both involve someone who was accused of the murder. Now, whether that person was wrongfully accused is a different story, and we'll dig into it in two different postures, but essentially the same question at the heart of the matter. Whether the court actually addresses that question, however, is a whole different story. That's this week here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Tuesday, May 6, 2024, and I am very pleased to have with me, in what is going to be a rather somber episode, two delightful colleagues of mine, one who has been on Short Circuit many times, and one who is a first-timer. So we'll get to, in a moment, our old-timer, and that is Dan Alban. He is going to discuss our case from the Sixth Circuit. And then we'll get to our newcomer, An Altik, who is going to discuss the Fifth Circuit case. Now, first, I want to start with Ann. So Ann has just joined us. She is a New Mexico native, so I'm sure she's had some interesting conversations with John Kramer about New Mexico since she joined us. Then she graduated from Georgetown Law, and what I want to ask her about, she worked in intellectual property law for a little while. Now, for those of you who aren't lawyers who are watching or listening, if you're a lawyer, intellectual property, and you don't do intellectual property, it's like one of the corners of law where you fear to go. It has its own kind of special rules. It even has its own special license for one part of the practice. And so I have thankfully hardly ever had to dig into an IP question. When I have, it's been with great trepidation. So there are these people out there who actually do that for a living, and I'm always kind of flabbergasted they're able to make it work. So, Ann, my question for you is this true? Should we be fearful? And maybe what should we know about doing intellectual property that us mere mortals know nothing about?
Yeah. So for me, it was a very natural path because I have a background in science. So obviously I wasn't quite as intimidated going into it. I have undergraduate degrees in science, and I attended 2 years of medical school before I changed my mind.
You sound more prepared than most of us. You know, and things like that.
Yeah, for me, it was actually more natural than diving into just general litigation because I spent a lot of time with pharmaceutical companies and reading the same scientific articles I had been reading. So in some ways, this is actually harder for me to jump into civil rights litigation, but a lot more exciting.
Well, true. Although I'm sure there are some exciting corners of trademark and patent law and all that kind of thing. But it's lovely to have you on the constitutional team here at IJ now. So appreciate you coming aboard. We'll hear from you more in a little bit. But first, we go to Dan. Now, Dan, I have to ask before we get into the meat of this Sixth Circuit case. Dan is someone where he will bring up authors and movies that no one else has ever heard of and know them intimately. Seems like a pretty cultured guy. So I am shamefully for me to say I have actually read very little Agatha Christie, despite quoting a little bit right there. Are you much of a reader of hers? I'm guessing maybe you've done a murder mystery or two inspired by her, or what's your Christie background?
I'm a pretty big fan of Agatha Christie, although I think I haven't read one of her novels recently. I tore through them in, I think, probably junior high through college. Occasionally go back and revisit them, but very fun novels to sort of dive into and become engrossed with for a few days. And extremely clever plots. She sometimes plays fair, sometimes doesn't. I have not organized any murder mystery parties based on Agatha Christie stories.
Okay. I did. Yeah, you're right about playing fair, or like, how would you ever see that coming? For some murder mysteries, you could make that statement. I did see The Mousetrap back in the day when I was visited London once. So
I also saw The Mousetrap in London. It was great.
Right. Well, be true to The Mousetrap. We will keep the secret in our hearts and not spoil it for any listeners or viewers. But we should now turn to the Sixth Circuit. So here is someone who is wrongfully accused. They're no longer behind bars, but it's been hard for this man to clear his name.
That's right. So the case is Percy Brown versus the Louisville-Jefferson County Metro Government and a individual police officer from the University of Louisville called Jeffrey Jewell. And it has quite a complex history and complicated set of facts. So I'm going to give you the short, simple version before we get into all the complications. The short version is there was a murder in 2004. A woman was murdered in Louisville. And Percy Brown ended up being accused of that murder and indicted for that murder. And ultimately, those charges were finally dropped in 2015. He filed suit about a year later, a little over a year later, for malicious prosecution and many other civil rights claims brought under Section 1983 against a number of detectives, as well as the Louisville Police Department and the University of Louisville. So the short version of how the case was dismissed and that dismissal was affirmed on appeal is that Section 1983 claims use the statute of limitations from the state where the claim would have accrued. So this is something that happened in Kentucky, and Kentucky is one of, I believe, 3 states that only have a 1-year statute of limitations for tort claims. That's an incredibly short period of time.
That's like a general tort claim. So slip and fall, whatever. It's not like just one special area.
That's right.
That is just crazy short.
It is crazy short, and only I think it's Kentucky, Tennessee, and Louisiana have this very short 1-year statute of limitations. Weirdly, Kentucky, I think, actually has a longer statute of limitations, a 2-year statute, if an automobile was involved. But for a regular tort claim, 1 year, which by itself I think is problematic in a number of ways. If someone's severely injured in an accident, they may not be able to recover from that accident and find an attorney and do all of those things within the 1-year period. Nonetheless, that's the baseline rule in a Section 1983 case. And so the problem was the claims against Mr. Brown were dismissed in February 2015, and he did not file his Section 1983 claim until July 2016, which is like a year and 4 months later, a year and 5 months later. On that basis, the court said, you're too late. The statute of limitations has run. The claim is time barred. Now, there's a lot more complexity to the case, so I'm going to just start adding a few layers of complexity. Yes, the claim was time barred because he brought his second lawsuit, actually his third lawsuit, in July 2016. But he had filed 2 previous lawsuits over the same charges and the same malicious prosecution claims back in, I believe it was 2009. And in those claims, well, the 2 cases were consolidated and then the claims were dismissed in part because the charges were still pending and the court said it could not resolve the claims that he raised until the criminal charges against him were resolved. So he was essentially kind of heck barred in his initial claim. So they said, oh, that was too early. And then sort of like a vicious version of Goldilocks, they said, well, and then your third claim is too late. Your third lawsuit is too late. And so he had to have timed it just perfectly right there in the middle. Now, that's not even the beginning of the complexity of the case, because what this case really involves is a man who was indicted 6 different times over a 10-year period on 34 different charges, and which he alleges, the basis of his lawsuit, is that this was all a conspiracy by Louisville area police, and the specific detectives named, to essentially pressure him to cooperate in a fraudulent check investigation that he may or may not have been at the center of. And so his version of events, which the court is supposed to take as true because it was deciding this on a judgment on the motion on the pleadings, his version of events is there was this large conspiracy by Louisville area police officers to pressure him to participate and testify in this fraudulent check investigation that involved him being charged with murder, rape, kidnapping, sodomy, a bajillion different felonies. And each time, and you might think, well, maybe this is just a really bad guy who did a bunch of bad stuff, and it's certainly possible. But again, the court's supposed to take his claims as true. What happened is each time, beginning in 2005 and ending in 2016, each time the charges were brought, they would then be dismissed. And this happened over and over again.
He never actually went to trial, right?
He never did, and he ended up spending 7 years in jail as a result of these successive series of indictments that were voluntarily dismissed by the prosecutors, sometimes a year later, sometimes many years later. No trial, no actual prosecution of this man, other than there was an indictment, charges were brought. He gets put in jail for indefinite periods of time, eventually released. And so his version of events is, I'm being persecuted by the Louisville police, and this murder in 2004 has nothing to do with me. Within a few days of that murder, the detectives already knew who actually committed the murder, and they instead, while interviewing someone about this fraudulent check investigation, there was some allegation tying this woman who was murdered to me, and then that kind of spiraled out of control into a series of allegations that he had committed all of these crimes based on testimony from people maybe associated with the murder victim. It's a crazy, crazy set of events. At the end of the day, though, the court says, well, look, that may be true, it may not be true. And I guess an important thing to point out here is this decision is only resolving Percy Brown's lawsuit against Jeffrey Jewell, the University of Louisville police officer. Everybody else is out of the lawsuit at this point. Some have been dismissed for various reasons. There was apparently a settlement with some of the remaining defendants. I have no idea if he received much compensation as part of that settlement. I don't really know how that worked. So at the time of this decision, and the basis of the case that was before the Sixth Circuit was just his lawsuit against University of Louisville police officer Jeffrey Jewell. And the problem for Mr. Brown in that instance is that Jewell is only alleged to have been involved in some early interrogations in 2004 that led to the murder charge and a couple of sort of weird sodomy charges that all ended up getting dismissed. But Brown can't tie Jewell to some of the subsequent charges that were brought. And so the court says, well, the best you can do is the murder charge. The murder charge, the indictment occurred in 2009. It was dismissed in 2015. You didn't file your lawsuit till July 2016. That's over a year after the lawsuit would have accrued, is the term that courts use to describe when you're able to bring suit. And so Brown was just out of luck, because whatever may have happened, even with some of the false indictments that continued to happen into 2015 and that were not dismissed until 2016, a few months before he filed his lawsuit, those couldn't be directly tied to Jewell himself, the University of Louisville police officer who conducted some of the initial interrogations in 2004. So it is difficult to explain how someone can spend 7 years in prison and not actually be charged, not actually be go to trial, have all charges dismissed out of these 6 indictments, 34 charges, and not have any recompense. Now, maybe he got something in the settlements with the other defendants. Let's hope so. But the court's rationale is this, and I'm going to quote from this is from the opinion. It says, in short, the charges against Brown constitute multiple, separable, overlapping prosecutions resolved on different dates for statute of limitations accrual purposes. Even if each violation of Brown's rights was an act in furtherance of a single overarching conspiracy to punish him for not cooperating with the check forging investigation, Brown's malicious prosecution claims arising out of the murder charge accrued when that murder charge was dismissed. And so, based on that, based on the idea that a conspiracy isn't a conspiracy is just the individual acts committed in furtherance of the conspiracy and not something that Jewel, by participating in the conspiracy early on, I guess is somehow can't be held responsible for things that occurred in the conspiracy much later, 11 years later. They say, well, if Jewel didn't do anything, after the charges that led to, or the murder charge that Brown was indicted for in 2009, and that was dismissed in February 2015, you're just too late.
So it's like they're saying you should have sued about the murder charge after it was dismissed, while probably he was in jail for one of these various other parts of the conspiracy. I mean, that's really
exactly.
What they're saying,
I mean,
right?
there were charges that remained until I believe it was April 2016. So he would have had to file suit while a bunch of other charges were still pending against him. He may I don't know the status of his incarceration during all of this, but he may have been incarcerated during some or all of that time because he had just been indicted again in February 2015, the day before the murder charges were indicted, before the murder charges were dropped. So it seems like a gigantic catch-22. And then he also kind of offers an argument that there was really this sort of continuing violation of his civil rights because the charges kept being filed and then dropped, and then they were pending during this entire time. But the court says no, that's just not how continuing violations work. One continuing violation might be you're being held in jail unlawfully, right?
Yeah.
But they say no. The continuing violations exist when the defendant has committed several distinct acts of wrongdoing, and the cumulative effect of these acts amounted to a constitutional violation. But if the defendant's separate acts of wrongdoing are individually actionable, the continuing violation doctrine does not apply. And they said, well, each of the indictments was individually actionable. You said that you elicited false testimony from witnesses, you invented testimony, you did a variety of things. Each one of those indictments was individually actionable, and so because of that, there's no way to invoke the continuing action doctrine. And so you end up with a court that sort of chops this up into little pieces and says, well, you can't sue about the whole thing. You can only sue about the individual things, and the thing you want to sue about, the time has passed to sue over it, even though you were indicted under a bunch of different charges, all related to the same conspiracy. During the 1 year period, you would have had to file suit. It's I'm sure his attorneys were extremely frustrated. I'm sure he was very exasperated by all of this. And again, this is something that goes back to 2004. It's being resolved by the Sixth Circuit now in 2025. This is over a lawsuit that he filed in 2016, and his initial lawsuits were filed in 2009. So you can sort of imagine how his life has been turned upside down for 20 plus years now, and then he ends up with this result that he can't bring his claim. Now, it may have been very difficult, right, for him to actually prove up these claims, but this was decided. This was decided at a motion on the pleadings stage, which is similar to a motion to dismiss. The court has to take the alleged facts as true, and so even if the court thought, well, it's implausible that all these officers were involved in this conspiracy, they were supposed to treat that as true. They do say they did that, but then they just sort of chop everything up and say, well, this officer really only did stuff at the very beginning, and at best we can tie what he did to the murder charges, and those were dropped in 2015. So too bad, so sad.
All right. And your thoughts?
Yeah, when I first started reading this, I honestly had to make one of those crazy charts with all the dates and the charges
Totally.
because I was so confused on what he was getting charged with and when. And I also thought it was very interesting that the court noted, oddly enough, there are no other cases with similar facts, which I think just sort of goes to how egregious these facts are. And, that doesn't actually indicate anything other than that. I don't have that much experience with malicious prosecution cases, so I sort of had some more general questions that I thought we could talk about.
Yeah.
The court seemed to really focus on this issue of separability, and I guess for his purposes, without us knowing, all the details, if the court found that it wasn't separable, would that actually have made that much of a difference? And then the other question I had is, towards the end, they also mentioned that there was no conviction, so he in some ways didn't suffer as much as I guess other people in these situations might. And is that something that courts always look to find a successful claim of malicious prosecution? I guess to what extent is, obviously we think he has suffered, and I think, the average person would agree with that. So does the court not take that into account? Do you need that conviction?
Dan, you want to take him?
So on the separability issue, yeah, I think if the court had considered this to all be part of a conspiracy to persecute/prosecute Percy Brown and pressure him into testifying or cooperating or whatever it was they wanted him to do with respect to the fraudulent check investigation, then yeah, the claim I think against the officer would have gone forward. Now, I think it'd be very difficult for him to establish that this single officer at the University of Louisville Police Department, who was maybe involved in, I think, 2 interrogations of witnesses in 2004, that he was really participating in this long conspiracy against Percy Brown, this 11-year, 12-year conspiracy. But, that would have been, things he could offer evidence about. And I doubt they would need to show that he continued to act as part of the conspiracy throughout the entire time if he was simply working with others who knew that they were committing wrongful acts, that they were violating Percy Brown's rights, but they did so kind of in disregard of his rights because they wanted to pressure him to comply. I think that the separability issue, if the court had gone the other way on it, he would have at least survived this, judgment for motion on the pleadings, even if he might not have been able to prove up his case at the discovery period. As to the conviction thing, I don't know about the formal standards for it, but I would think that anyone would feel that if they were imprisoned for 7 years and not ever even had a chance to go to trial, that would be some kind of pretty serious wrong against them and a pretty serious injury. And I bet very much that if, any judge had that happen to a relative of theirs, a son, a daughter, anyone else, they would think it was a pretty serious injury and violation of their rights. But, sometimes criminal defendants don't get treated the same way by the courts. One example of how weird all of these charges and everything are, the first set of charges related to allegations of sodomy, which it's crazy how much they're prosecuting sodomy in this case. Yeah. He's indicted multiple times for it. But the weird thing is, the witness testified that Percy Brown sexually assaulted the murder victim and forced her to commit sodomy with him, but when he's indicted with sodomy charges against that witness, not against the murder victim. And that witness apparently never testified that he had committed sodomy with her. So it's very weird how all of these allegations turn into indictments that seem to be like weird Hall of Mirrors versions of what's actually in the witness statements. I don't know how much of that is, potential differences between his complaint and other documents that might differ. I just don't know, but it is very, very weird and puzzling.
Well, yeah, and taking those facts as they're pled and to believe them, you really do get the sense that these charges were not charges that were meant to be proved before a jury. They're leverage for this check kiting scandal or whatever it is that I mean, it sounds so minor compared to the murder that was prosecuted. And of course, when we know about how often plea bargaining is used and having witnesses play against each other in the criminal justice system, probably speaks to a much larger use of whether in this office or all kinds of prosecutors' office where you have charges brought where you never intend to actually bring them to trial, and if you drop them at some point when you got what you wanted, or maybe if you lose interest in that witness, it just never comes up again, right? And you never have a lawsuit like this. One other, and maybe you can speak to this, Dan. You probably read the case a little more closely than I did, because Anne, I was trying to use a chart at one point. I don't know what the settlements were otherwise, but usually in a case like this, you have a really hard time suing the actual prosecutors, because the prosecutors get immunity for the work they do as an actual prosecutor, and it's like you kind of have to find this little bit of the case that they did with the officers where they're investigating before they were really a prosecutor to even have liability. And so I'm sure that was shaping why they're just going after this cop at this point and not whoever else was involved.
Yeah, I think that's absolutely right. I mean, they're the prosecutors, are protected by immunity, and it does seem like a lot of these charges were brought not with a real intention to pursue them and bring them to trial. They were trying to pressure a plea agreement. What's remarkable here is that he apparently never signed a plea agreement on any of these charges, which if he had, that would have been a basis for a heck bar for challenging the malicious prosecution on at least that charge and probably a bunch of related charges. But he didn't do it, and he, spent 7 years in jail as a result. But nonetheless, despite kind of doing the right thing in terms of not confessing to something that you don't believe you did, just to, essentially, because he probably at some point could have just signed a plea deal and been out on time served and not had really any continuing issues. But I think they really wanted more information from him about this check fraud scheme, and boy, did they really apply the thumbscrews in a way that it sure looks like a pretty, at least as portrayed by him, a pretty oppressive persecution of someone for what I would think is a fairly, minor crime. Now, I don't know what the extent of this supposed check fraud scheme was, but as compared to murder, kidnapping, rape, all these other crimes that he's charged with, it doesn't seem like check fraud really is in the same league as those.
One very last thing, just for maybe some listeners, you mentioned heck bar. So that is the doctrine, if I'm right, from this case called Heck, nothing to do with heck or hell, that if someone is suing about a malicious prosecution, so that already happened, they can't have been convicted for the crime, whether it's they plea guilty or a jury finds them convicted. They have to have it either thrown out or in some way resolved in that they're not found guilty, because then it's basically like a settlement. So then you can't go in and challenge it later. Is that basically right?
That's right, yeah, and it sometimes gets extended to related charges or sort of subsidiary charges. But yeah, even if you just plead to a crime, plead guilty, that can bar your ability to bring a civil rights claim later. Even if you uncover evidence that there was serious wrongdoing, the courts just say that is a bar to you pursuing a malicious prosecution claim. And yeah, sometimes it can wipe out not just malicious prosecution claims about that related to that conviction, but a bunch of related claims as well. And here, it's hard to know which claims would have been related or not, but he did not plead to any of them. And so there was not an actual heck bar at issue. There was a sort of proto heck bar in his 2009 cases. It's not really a heck bar issue, but similar. The charges were still pending, and so the courts couldn't rule at the time.
That's the kind of Goldilocks problem that
Yeah.
you were talking about. Well, we're going to go into another problem now, and this is a long-running case that I'm sure many viewers and listeners have heard about, or maybe, and it was years ago that they heard or read about it, and that is this fellow Rodney Reed. So he has been on death row for many, many, many years now. He's been up and down the court system a number of times. I know a lot of people have written about him, and evidence, not just the stuff we're going to talk about today, but other evidence that's come to light that shows that he was wrongfully convicted. We're not going to talk about all that today, but if people want, we'll put a couple links in the show notes about other journalists who have written about his case. But the latest chapter of his case has to do with DNA evidence of the crime that he is accused of committing, which is the murder of this woman back in the 1990s. And his case went to the Supreme Court, actually, and he won. But what he won on was a chance to get into that evidence on remand, and now the Fifth Circuit has ruled not in his favor on that. On remand. So, Anne, take it away. Again, just a small piece of this very, very long-running case, but it's a very serious matter, and curious your analysis.
So I'm just going to give basic, bare bones facts of the case because it's very complex and I want to focus on the Supreme Court decision and the Fifth Circuit decision. So Reed was convicted of murder by a jury trial back in 1996, and he did receive a death sentence. Now, recently, in 2014, he filed a lawsuit asking for retesting of DNA evidence on certain objects related to his trial. Interestingly enough, there is another way for him to do that. He's able to ask the prosecutor outside of the judicial system whether he's willing to order some retesting. And that did happen in this case, but not all of the items that he asked for, because I believe he asked for over 40 items to be retested. At the state trial level, the state denied his claim, finding that he would probably still be convicted regardless of what the results were, and he was likely trying to unreasonably delay his sentence. The date that he filed that lawsuit actually was also the date that they were going to choose a date for his execution. So understandably, he's trying to delay that. Now, at the appellate level, the appeals court affirmed the state trial court's findings and ultimately denied a rehearing on that matter. So the issue went up to the Supreme Court on whether the statute of limitations for him to challenge this decision started when the state trial court denied the claim or when the appeals court denied the rehearing. And I believe the main circuit split was with the 11th Circuit, but it was an issue that was ripe for Supreme Court taking. And at the Supreme Court, a majority of the justices found that the best time or the correct time to start that clock is actually when the appellate court denied rehearing as opposed to when the state trial court denied it the first time. Now, there were a couple of dissents. Justice Thomas dissented, mainly stating that the Rooker-Feldman doctrine should have applied, and Alito separately dissented, joined by Gorsuch, stating that they believed the correct timing was actually when the state trial court denied his claim as opposed to the Court of Appeals denying his claim. And ultimately, like you said, Reed did win, so that meant that the Supreme Court said that it was a timely suit and he was still able to bring a due process claim challenging the denial. And so that's what the Fifth Circuit recently decided and was able to get to the merits of the issue. Now, Reed brought three main arguments, and I think the first one is the best one, so I'm going to save that one for last. And the second claim that he brought is that this statute unfairly inculpates third parties. And this is slightly, I would say that it's a little bit harder with his facts, and it might be different with different facts, but the statute basically says that unless this evidence is retested and you are completely cleared and no longer convicted, then they're going to deny the chance to retest the evidence. And here, Reed's main theory was that he was actually having an affair with the woman, and the killer may have been her jealous fiance. And so testing the other pieces of evidence may have pointed to the fiance. I think here it just didn't really work out because the nature of where the murder happened and the fact that, finding the fiance's evidence in his own car or around his own fiance isn't necessarily going to be surprising or indicative unless they were, apart for a really extended period of time. And so that's really just a factual thing that I think just didn't work in his favor. His next claim is that it's not an unreasonable delay because holding that against him would be like he would have to predict the different types of DNA evidence and methods that would come out in the future. And while that is true, I think that in this case he did have plenty of time to bring the claim technically. This whole issue that went up on the Supreme Court is that it may be out of the statute of limitations. And so it's clear that he didn't bring this immediately when there was a chance to bring the case. And he also didn't ask for retesting until the very date that his execution date was meant to be set. So those facts just really didn't work in his favor in trying to deny that he was unreasonably delaying it.
Yeah, it seemed like the court did that. The coincidence of the date, if you want to call it that, the court was quite suspicious of that, basically.
Yeah.
But
Yeah,
the touch DNA technology had only recently been developed, right? I don't remember the exact timeline, but I remember I hadn't even heard about it, but that was some new technology that you could not predict would be available, and
Certainly not in 1996.
No, I mean, yeah. I don't remember what the time frame is that it was developed in. Maybe they're saying, well, you should have filed something 3 years ago instead of 1 year ago, but
yeah, I do think it was actually around that time frame. I think it was developed in 2011, I believe.
Okay.
And so, yes, it is a matter of a couple years, but perhaps in this case they just found that was enough to say, well, maybe you should have filed it 2 years earlier then. And his first claim is the non-contamination claim, which is basically saying it's not fair to hold it against the prisoners if the state messes up something in terms of handling custody of the evidence so that they're not able to perform retesting satisfactorily and get some actual results. And the Fifth Circuit sort of first, I feel like it's kind of punting to say, yes, he was convicted, so there's a lower standard applied because he's lost his presumption of innocence. And while that's true, it doesn't really answer the question of how prisoners are supposed to deal with the fact that the government is the one who's handling all the evidence. The next thing the government says is that, well, someone's got to keep custody of it, and it's going to be the government. And they sort of just revert back to a good faith basis. That they believe that government's trying their best, and so they're probably doing their best to take care of the evidence. And once again, I'm sure that's true, and to an extent we can hope that, this very crucial pieces of evidence are being taken care of by the government. But in the off chance that it's not, I think it's really hard to prove that the state mishandled evidence, and there's no way for prisoners to know that. So for the panel to point that out as an example of a way to get around this is, to me, sort of a non-starter, because that's just going to be impossible unless it's there's a scandal or some way that we're able to find out that the property was or the evidence was mishandled. I think the only thing that makes me feel a little bit better in general about the fact that the panel held that there was no due process violation and the statute does sort of work is that it actually does require a lot of different factors. I think if they were able to deny all retesting based on just the contamination of evidence, that would be obviously a huge issue. We wouldn't actually know if the evidence was mishandled in any way, we wouldn't be able to really inquire into that further. But just because there are other factors such as, not wanting to unreasonably delay or the preponderance of the evidence that the results of the DNA testing could actually change the conviction, I think at least gives us a little bit more faith in the process. But I'd love to hear your guys' thoughts on it.
Yeah, Dan?
Yeah, the part of the opinion that I thought was sort of weakest and where the court punted the most was in the discussion of, well, somebody's got to hold on to the evidence, and it's implausible that it would be anyone besides the state. Therefore, we must afford a presumption of good faith to how that evidence is kept. And I just think that makes a leap of logic that isn't the sort of logic that's applied in most other circumstances. Generally, if a party is in custody of evidence, or let's say there's a series of emails revealing some sort of fraud or something within the company, and those emails go missing or get destroyed, you don't say, well, there's a good faith presumption that people keep their emails and retain evidence related to cases because they're supposed to do that. You say, there's going to be evidentiary presumptions entered against you if you're unable to produce this evidence. And
spoliation, they call it.
Yeah, spoliation works like that. Lots of principles of law work like that. I think one of the simpler ones that you learn fairly early on in your 1L year is about the presumption that whoever drafts the contract is the presumptions go against them on interpreting the contract. And it seems to me, yes, somebody has to draft the contract. Somebody has to hold on to the evidence. But the mere fact that somebody has to do it doesn't mean that they then also receive the presumption. I mean, it's sort of like the cake cutting rule, right? Like, yeah, somebody's got to cut the cake, but the best way to make sure you get an even amount of cake for both people is for the other person to get to choose the piece. And here the court is simply saying, yeah, somebody's got to cut the cake, and we're going to afford a presumption of good faith that the government's going to try to cut the cake as evenly as possible, but we'll let them have first pick also, and it's only if they sort of deign to allow some testing that we'll do it. So I just found that very odd and not persuasive.
And one confusing part about the opinion to me is that, in a sense, this is a challenge to the constitutionality of this state rule about DNA testing. So in a sense, it's kind of not about his own, although it is about the procedures for his own DNA being tested. It's whether this law allowed him process when he tried to use it in state court, which kind of put another layer of buffer on the state side. Do I have that right, Anne?
Yeah, that's actually something that I believe it was in Justice Thomas's dissent that he brought up. And in some ways, this was sort of him asking for appellate review again, as opposed to the actual due process claim regarding the statute itself. And something that I believe was also in the dissent is that he actually also appealed up to the Supreme Court the very initial denial of rehearing by the Court of Appeals, and they denied cert on that. And then he proceeded to bring the 1983 claim for due process. So, yeah, it is an extra level of intricacy.
Right.
And I think he also, had both facial and as applied due process claims here that, boy, a facial claim, the way the courts interpret facial claims these days, and certainly the way the Fifth Circuit does, is in every instance in which the statute is applied, it's unlawful. That seems like biting off way more than he could chew, because in some instances, people presumably get the testing they want and could be exonerated by that, or could affect the outcome of their case. And
seemed like that court wasn't too impressed by the facial part. Yeah.
And given the court's kind of willingness to sort of bend over backwards and imagine scenarios in which someone might be able to overcome this presumption of good faith using who knows what evidence, the idea that you're going to prevail on a facial claim, and just for our viewers who may not be familiar, a facial claim is when you're challenging a statute in all applications, not just against you, but against anyone who it might be applied to. So literally anyone in Texas who wants to get their DNA tested under, what is it, Rule 64, something like that.
42.
I can't remember the
Maybe
number.
you're right.
I don't have it on the page in front of me. Chapter 64 of the Texas Code. Anyone who wants to get their DNA tested, who's a criminal who's been convicted, that statute doesn't afford them due process. Whereas an as-applied claim is as applied to me, Mr. Reed, my due process rights are violated. It's generally much easier to prevail on a as-applied claim versus a facial claim.
Yeah. Well, we will see where this case goes. I'm sure, given the nature of the case, this is going to go up to the Supreme Court again. And I have to say, I don't know the intricacies of any other litigation. Capital litigation, of course, is often incredibly complicated, incredibly long, and it's always, of course, incredibly serious. So, Anne, thank you for explaining us through that. And Dan, thank you for the earlier case. I've been corrected also that I think I said we were in the year 2024 at the beginning of the show. Actually, it is now, you will be happy to know, everyone, 2025. It's taken till May till I figure that out, but maybe one of these months I'll get it right. So thank you both for coming on. Thank you, everyone, for listening. Please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.